Well, good morning, everybody, and welcome to the webinar. I am Alexander Wilson. I'm a tax manager at ETC Tax, and I'm chairing our discussion today. I'm delighted that we're hosting this webinar with Quantuma. This morning, we'll be discussing some of the issues that arise with the loan charge, where we are now, what's changed, and some of the considerations which come up when we're resolving these issues. Which in some cases, of course, go back very many years. The Q&A function is open on this webinar, so please do feel free to submit your own questions in real time. We've already had some questions in advance of the webinar, so we'll try our best to answer these at the end. Now, a bit of housekeeping: if we do experience some technical difficulties, please just bear with us. We have a team behind the scenes to make sure things are picked up if need be. So it's my pleasure now to introduce our speakers. Firstly, Rehan Ahmed from Quantuma. Rehan is a managing director in the Restructuring and Insolvency team. He is based in Leeds. He provides advice to distressed companies on their formal and informal options, whilst implementing strategies to assist with turnaround and recovery. Although Rehan has dealt with many sectors over his career, he's gained a reputation for assisting businesses in the manufacturing, construction, food and retail sectors. Our next panelist, Brian Burke, is also from Quantuma. Brian is a restructuring and insolvency director, and his experience includes advising businesses who have found themselves in difficult financial situations by identifying solutions to help reach an appropriate agreement. He is the firm's leading advisor on tax planning schemes, so we're delighted that he's with us today. He notes that these have been subject to much greater HMRC scrutiny recently, and he regularly advises businesses on how to manage the financial uncertainty caused by their receiving follower notices and accelerated payment notices. We're also joined by my colleague, Thomas Slipanczewski of ETC Tax. Thomas is a tax advisor. He regularly advises clients on a broad range of tax inquiries. His experience includes private client tax, tax investigations, settlements, residence and domicile issues, restructuring and crypto assets. He's currently studying towards the Association of Tax Technicians and Chartered Tax Advisor qualifications. Finally, I turn to myself. I'm a barrister and a Chartered Tax Advisor from ETC Tax. I specialise in all matters IR35 and off payroll, and have a keen interest in HMRC investigations at all levels, up to tribunal, and advise on a wide range of tax matters. I guess that most of you will be aware of the nature of the loan charge itself. Perhaps if I ask Thomas to give us an introduction of it, and tell us where we're at now.
Thank you, Alex. So the loan charge was first announced in 2016 and was introduced into the Finance Act 2017. In summary, the loan charge is a one-off charge to income tax and national insurance on all relevant loans and quasi-loans outstanding as at the 5th of April 2019. Overall, in terms of the scale of the loan charge, it is estimated that in excess of 50,000 people have used a loan scheme in some way, shape or form. Since its introduction, the loan charge has evolved significantly. The most recent iteration of the loan charge, as amended following the Morse review, applies to all relevant loans and quasi-loans issued between the 9th of December 2010 and the 5th of April 2019. Generally, the loan charge will give rise to a relevant step as at the 5th of April 2019. However, following the Morse review, the legislation provides for taxpayers to spread their outstanding loan balance over 3 years evenly. That's in 2018-19, 2019-20 and 2020-2021. The loan charge will not apply to any outstanding loans issued between the 9th of September 2010 and 6th of April 2016, where a reasonable disclosure has been made and HMRC did not take steps to recover that amount. And where the taxpayer has already settled their liability prior to the Morse review, and following the changes brought in after the Morse review, their circumstances render that they fall outside of the loan charge and they will be due a refund of any settled amount. The tax charge in relation to the loan charge arose as at the 5th of April 2019, and that's now been crystallised. So yeah, thank you, Alex. That's a brief overview. Oh, you're on mute, Alex, sorry.
Sorry. To summarise that, although the loan charge post Morse review was cut off from pre-December 2010, that doesn't mean that the loans don't give rise to a liability before then. It's just the loan charge itself that ceases. Is that the case? Yes, absolutely. And this is also an important factor to bear in mind as well. That although the loan charge is a relevant factor and consideration, although somebody may fall outside of the loan charge, they may have open years that relate to pre-2010 arrangements, or still there might be other considerations when you settle the loan charge or when you seek to deal with the loan charge, where you pay the loan charge, that isn't always the end of the matter, and therefore you may have open inquiries which may give rise to a further tax charge down the road, or an interest payment due. And you talked about the option to spread the loan charge over 3 years. This question I've been asked before, but that doesn't mean you're paying it over 3 years. It means you're spreading the liability over tax years for calculation purposes. Yes, absolutely. So the way that it works is that under the general rule, the relevant step arises on the 5th of April 2019, which gives rise to the tax charge. Where you split it over 3 years, the relevant step arises over the 3 years, as noted before. The issue with the 3-year spread as such is that particularly where you've left reporting the loan charge until late on, you join the 3-year spread almost halfway through the 3-year process, and therefore the way that payments on account work mean that you effectively pay 5/6 of the tax liability between the 30th of April 2020, the 30th of September 2020 and the 31st of January 2021, leaving 1/6 of the outstanding payment due on the 31st of July 2020. So in effect, it doesn't really help taxpayers that much. No, indeed. I think it was a measure that was intended to be a bit of a sweetener. But I think I've even seen the case where I did the calculations and it turned out to be worse for the taxpayer to spread it over 3 years because they lost their personal allowance for all 3 years. Yeah. There we go. I suppose the other development that people are watching with some interest are the challenges in the courts about this. We've seen the human rights challenge, the human rights law, not to be confused with European Union law, two very different things, of course. In the case of Zeeman in the High Court, now that was a loss for the taxpayer, a win for HMRC, but we understand that is being appealed to the Court of Appeal. There, effectively, the argument is that the loan charge is not lawful or proportionate, and the taxpayer would have to demonstrate that it is unlawful and disproportionate in order to get rid of the loan charge. What the prospects of success for that are, well, we'll wait and see. We also anticipate a challenge on EU law, which is on its way to the High Court. The test is somewhat different there. The state has to just demonstrate, rather, that the measure is justified and proportionate. So not the same test, but some overlap. And some interesting arguments about whether or not the loan charge would have to be discriminatory in order to trigger EU law or not. I think the point to watch therefore is that the terms of the withdrawal bill do empower the government to remove any remedy under EU law as matters stand. So although it's a remedy that's open now for anyone who issues a challenge at this point, that may fall away. Now, there's been some further developments sort of touching on case law, Thomas, in relation to pre-2010 liabilities, as we touched on. Can you give us a quick overview of those?
Yes, absolutely. Thank you. So, as we noted before, that although the loan charge doesn't necessarily apply to what we call pre-2010 years, it doesn't necessarily mean that there is no liability as such, or no remedy for HMRC to seek taxpayers. So, and there has been a significant development recently in relation to this. There have been 3 cases. So where the loan charge does not apply because loan arrangements were effected before the 9th of December 2010, following the Rangers decision, many taxpayers have sought to argue that the tax and NIC liability is that of the employer. This is built on the basis that under the PAYE regulations, the employer is responsible for deducting and paying over any PAYE due. So, however, from this, in many cases, HMRC have sought to argue that it has an inherent discretion found in section 684(7a) of ETEPA 2003. The first tier tribunal in 3 cases, Hoey, Higgs and Lancashire, have confirmed that HMRC does have this discretion. However, in the most recent decision in Lancashire, the first tier tribunal states that HMRC must exercise its discretion contemporaneously and cannot do so retrospectively. Therefore, this will potentially present a bit of an issue for HMRC going forward, where it does seek to rely on this argument. Now, just to stress, this is only a first tier decision, and we are awaiting the upper tier decision in Hoey, which could effectively turn this on its head, or it could, further agree with this, and therefore we do that at any point now. However, on the basis of Lancashire as the law stands today, HMRC will have to seek to justify that they did exercise their discretion and it was contemporaneous. Where the taxpayer doesn't know that the discretion was exercised, it will be very difficult for them to do so, because the law requires that HMRC direct the relevant party, which would effectively be the employer in that circumstance.
Thank you, Thomas. I think the final issue we were going to touch on is how inheritance tax comes into all of this. I think that's a surprise to a lot of individuals who see themselves having to deal with this situation. How on earth does inheritance tax arise? Well, I think we'll just briefly explain that in terms of that a lot of these structures used trust vehicles in order to deliver the promised benefits, and inheritance tax arises in a number of situations where a trust is involved under UK law, largely where money comes out of a trust. That gives rise to a charge to inheritance tax, and we were talking about loans being written off. If that happens, that's effectively the same as the trust giving money to the beneficiary. So that's how inheritance tax arises. But I think, Thomas, we're seeing that HMRC settlement terms are covering that off. That's right, isn't it?
Yes, absolutely. So the default position within HMRC settlement terms was to include IHT, which would effectively deem that the loans would be written off within 30 days or a specific period of the date of settlement, which would then give rise to an IHT charge.
And the alternative is to meet that head on, challenge HMRC to prove that there is an IHT liability. That's the approach we're taking at the moment, I think, in most cases, and I think we're fairly confident of our arguments on that. I imagine you'd agree with that, Thomas.
Yes, absolutely. IHT, it does, from an unfairness point, I know this is tax, but it does seem particularly unfair, particularly where on one hand HMRC would suggest that this is income, and then on the other hand would then also suggest that this is capital. I do understand their argument in the sense that following Rangers, the payments were made to the trust out of post-tax income. However, I think the whole arrangement is relevant, and there are circumstances where HMRC do draw on relevant case law and do ask the court to look at the arrangements in the whole, and I don't think that would be unreasonable to do so in this sort of circumstance.
No, absolutely. Well, Rehan and Brian, you've been very patient listening to Thomas and to me waffling on about tax.
Just a quick question, Thomas, Alex.
Yes, please do.
Thomas, you mentioned that in the Morse review that was if they made reasonable disclosure, they'll be exempt from certain things. So, in what's reasonable disclosure? Or is there any case law recently on reasonable disclosure?
Yeah, so the relevant law here is found in, I think off the top of my head, it's section 17 of the Finance Act 2020. Now, in terms of what a reasonable disclosure is, the legislation does actually list what it considers to be a reasonable disclosure. And this would, in summary, this would require the taxpayer or the company, whether on a personal tax return or a corporate tax return, alongside the relevant documents that are submitted with the tax return, such as maybe accounts, to specify that a loan has been paid, the amounts of those, who it's been paid to, and also there's a final requirement which specifies that, I can't remember the exact wording, but it's along the lines of that a reasonable person looking at these arrangements would consider that there would likely be a tax consequence flowing from these arrangements. There are a number of other things to consider, such as whether or not a DOTAS number has been included on the returns or relevant documents. The more interesting, or I suppose contentious issue, which hasn't been clarified as such, is what amounts to HMRC protecting their position. So you would automatically think that HMRC protecting their position would certainly be satisfied where they've issued an inquiry to the individual or an assessment. However, or even a Reg 80 to the employer, you'd absolutely think that would be satisfied. However, there are questions as to whether or not that would be satisfied if they had issued an inquiry to the company, which relates to corporation tax as such, as opposed to PAYE, and therefore these sorts of questions I think will be thrashed out probably in litigation in due course.
Yeah, you said that I think at the beginning of the answer you said either the company or individual. Now, is it one or the other, or does both have to make a reasonable disclosure? It
can be one or the other. However, the relevant returns or disclosures can be made by either or the employer or the employee, and you do see that on some returns where individuals have put information onto their returns, or you will also see on the companies where they have, or within the company accounts.
I think this is perhaps a point where we can inject this question from Andrew Wilson. I thought there was a 30th of September 2020 deadline for making these declarations. Is that not the case? And what are the implications for missing that deadline?
Yes, that's absolutely correct. So the each individual that falls within the loan charge was required to report and pay the loan charge as per the 30th of September deadline. There was also a similar deadline in relation to settlements. The only way that you could potentially go beyond that is where you then implement the 3-year spread as such. However, you report that on your return for 18-19, and you state that you will then follow through in the following 2 years with the other two, with the 2/3 split over the 2 years.
And any advice for anyone who hasn't reported by that deadline, I suppose, would be reported as soon as you can.
Yes, yeah, and in terms of the consequence of not reporting that, there are of course late filing penalties and also late payment penalties as well, which can accrue alongside the usual interest.
Thank you, Thomas. Yes, Rehan and Brian, thank you for the question, Rehan. But what impact does the loan charge have on a company?
So the loan charge, in essence, is in essence it's an action against the directors personally. It does create a liability for the directors. or the beneficiaries of the loan charge. So in some cases, it might not be a real benefit for, or not benefit, it might not be an action that the companies necessarily need to take. But what it does do is it creates a liability for the company on a tax basis, and so in some cases there will be a liability that the company needs to undertake. And now what we've had in the past is we have had a couple of companies come to us for advice on whether we can liquidate the company or take any sort of various different actions. Now we have looked at, and we have actually liquidated a number of companies and been the liquidators for them. The problem it does create is that from our perspective, the loan charge, because it's on the individual's name, the loan charge is on the individual's name. As a liquidator of the company, we don't necessarily go after the tax of the tax that HMRC are claiming for. We're looking at an angle that the money that's been extracted on the loan charges, they're not necessarily debt. They're actually actions that the director has taken, which has caused the company to go into liquidation. So from our angle, we're going after a certain set of actions as a liquidator, and then on the other angle, the HMRC will be making a claim in the liquidation, and potentially, and against the director for the money that they've benefited from. So it's essentially, it's almost like a different debt that we are pursuing. So as a liquidator, we have a number of actions under misfeasance, transaction defaulting creditors, and in some cases they could be classed as an illegal dividend. So from our angle, we are pursuing them for a different debt. In a weird way, it's kind of the same debt, but it is a different debt on a legal angle. So we will be going after them, and HMRC will be going after them. So in some cases, a lot of people have questioned and have asked me, what's the benefit of us liquidating? I mean, Brian, I don't know if you've seen anything from your angle. Or
I think the interesting piece to me with the introduction of the loan charge is primarily the fact we've now got a number of competing consensual yet conflicting issues that arise. So paying the loan charge does not settle the tax liability. There is still an underlying tax liability there. Yes, it may have been first created in the company. That's still there. The loan charge and passing it back to an individual, or even, in some individuals' cases, they're not putting their loan charge on their self-assessment returns. They're basically saying the employer should actually deal with this, which would be natural in the first instance. The bit that sort of comes through quite heavily in all of this is you suddenly have different liabilities with different calculations based on different criteria and different effect. There is multiple channels available in terms of discussion. So whilst that has been closed down to some degree by the new sort of phone lines that HMRC have put in place specifically for the loan charge, up until 30th September, we were still talking about settlements. 30th September, that's fallen away. There are still a few that are moving along. There's now the loan charge, but there's also the autumn settlement guidance. So there is still an opportunity to settle, but the settlement relates to the entire tax liability, not the loan charge itself. But with the fact that you're not actually getting a double taxation, ultimately the question is how much do you owe? And I have to say, consistently over the last year or two, I've seen ever-changing figures. And okay, admittedly, there's interest in there and so on and so forth. But the application of Section 223, Section 455, corporation tax allowances, and so on and so forth. The reality is that you can end up in a situation where I guess the directors of the company are in a position where they're fighting on multiple fronts, shall we say? And obviously, from our perspective as a liquidator, or a prospective liquidator, the question is the solvency of the company, and that's really what it comes down to. And then from there, I suppose the duties that fall upon those directors and what they should do and how they should act appropriately.
It sounds as though there are competing interests going on there. You've got HMRC's claim, you've got your claim as a liquidator. How do you resolve those?
Well, the thing is that if you think about it, the HMRC in a liquidation are a creditor. So they might not be the only creditor, but quite often where tax planning is involved, they're certainly the most substantial. So they have a claim in the liquidation. However, they still have the right to, for example, go from a Reg 80 to a Reg 81 using Part 7A, or to apply the loan charge to the individual. If an individual pays the loan charge, obviously they're not going to get taxed twice. So in theory, there should be a reduction in HMRC's claim in the liquidation. And this is an ongoing, let's call it issue, where the sands are still moving. So if you've got a company goes into liquidation, HMRC put in a claim, that would be for whatever they believe that is owed. That will be an initial claim, not a final claim. An individual suddenly decides, okay, I've got the money, I'm paying the loan charge. They pay the loan charge, but obviously a portion of that has actually arisen in the company. At which point HMRC would take away the PAYE element in relation to what's been paid. The result of that is that the claim HMRC have in liquidation reduces. And likewise the other way around. If we've done this multiple times, we reach a settlement between us as liquidators and the directors of the company. That extinguishes all liabilities. Generally speaking, we have to engage with HMRC as a principal creditor. In many instances, we have them as a tripartite. So we'll have them as party to the settlement, and then the loan charge will fall away.
I think that rather deals with a question that we had in advance of the webinar from Neil Davies of ND and P solicitors. A common theme in such cases is the overlap between apparently competing claims of HMRC and of a liquidator in misfeasance. In such cases, aside from a tripartite agreement, how else can such matters be resolved? Is there anything else, anything to add to that?
I think with the tripartite agreement, it's definitely useful in the sense that, as Brian said, the majority of the creditor in most of these cases is HMRC. So they're going to get a dividend from us if we settle from in liquidation anyway. But what we're finding at the moment is HMRC are coming up with weird and wonderful settlement agreements, and that's probably where the sticking point is going to be, trying to get HMRC to understand that, you know what, this is a good deal for you guys, and if you don't do a deal, you're going to get half of nothing. So it's one of those trying to get HMRC to be commercial and understand that, you know what, do this deal because you're going to get nothing. And we've seen it recently as well. I think, Brian, you were mentioning a couple of days ago about one of the deals that you were trying to get over the line.
And I think one of the bits that's been interesting, shall we say, if you go up to the cusp of 30th September, HMRC's criteria in terms of looking at their outcomes, if you were putting forward a substandard settlement, which is a settlement where you can demonstrate that an individual cannot pay in full, and they were putting forward a substantial sum in comparison to their liability, HMRC would often look at what the loan charge would deliver for them and make a decision that they wouldn't actually agree to a settlement. They would rather actually wait for the loan charge, even though the underlying financial position of the individual hasn't changed. Which in itself is a strange position to be in. It's almost pick the highest number you can get and work from there. Now, I understand completely that HMRC's view is if somebody can pay, they should pay. And as per everything, that's the way of the world. I have no issue with that as a liquidator. That's what I'd fully expect. But we do have, I suppose, we have different tools at our disposal. As a liquidator, our tool is the Insolvency Act and the Companies Act. As HMRC, their tool is ITEPA and tax legislation. The crossover and the anomalies are where we generate friction, and those are yet to be dealt with in different ways. But the one thing which has become quite interesting is the nature of settlement. So initially, a tripartite settlement would be done by a deed, So it'd be a deed with the liquidator, HMRC, and the individual, and that was absolutely fine. Subsequently, I've done ones where there's been an agreement between myself and the third party, and a side letter from HMRC. On the basis that if this person performs in this particular way, they will commit to do certain things, or not, as the case may be, which is obviously the more logical point. But it has to be done on a case-by-case basis, and I think that's the key thing here, is that every situation is slightly different. Yes, there are common themes, but ultimately each one has to be looked at on the face of itself, and some logical decisions made in terms of what the most appropriate direction of travel is, what the right approach is, what's the best thing to do.
And what about liability, personal liability for directors, perhaps those that have been involved in delivering these schemes?
Sorry, when you say delivering the schemes, do you mean the promoters, or do you mean the directors of a company who've utilised them?
Both and either.
Okay. Well, I'm sure Thomas could probably help in respect to the new powers and the continuing focus of HMRC on evasion, and also on the promoters and umbrellas that are selling questionable schemes and so on and so forth. And obviously those powers are significantly enhanced over the last couple of years. Additionally, obviously they now have powers to look at companies who are let's say promoting or assisting, and those I'm sure will come more and more to the fore. But the one bit there which strikes me is that HMRC's position has always been to change behaviours. I think over the course of the last 3, 4, 5 years, they've made a substantial change of behaviour. The volume and quantum of the schemes that are there, what's going on, and the nature of tax avoidance has moved completely. We are in a very much a different world now than we were a decade ago. As far as I guess the liability of the directors of a company would be concerned, it's not so much the fact of, first and foremost, the question becomes, if, say, for example, a liquidator or an office holder, administrator or whatever, primarily a liquidator, what are their duties? Their duty is to act in the best interest of creditors. To do that, they therefore must look to maximise realisations. If there are therefore claims that are available to them, again, it may be, it could be contractual, it could be whatever, but in this particular case, in relation to the actions of the directors. So, as Rehan said, misfeasance, transaction defrauding creditors, illegal dividends, transaction at undervalue or preference. They have to pursue that. Likewise, if the company has got a liability they can't meet, and therefore this question is over its solvency, the directors have a fiduciary duty to act in the best interest of creditors. So that there are a number of balancing considerations, and it does put directors potentially at risk. And for anyone in that situation, I'd recommend that they got advice, and that they, and also that they started to actually give serious consideration to things like board minutes, making decisions, documenting them, and making sure that they have a reasonable position where that if you have a look back at a future time, that somebody can actually say that that was a reasonable decision to make at that particular moment in time, and that would be a sensible thing to have.
Absolutely. And what about the position of individuals? Obviously, the loan charge gives rise to substantial liabilities for individuals. How does are they assisted by IVAs or the like, or is that a problem?
Well, potentially. I mean, first and foremost, I guess with most of these situations, the rationale is to engage with your creditor, in this case HMRC, to see if you can reach an agreement. Now, HMRC have pre-published a number of different things. It's not their intention to force people to sell their homes. It's not their intention to bankrupt people. There is no such thing as a minimum length of a time to pay. If you're paid a certain amount, you get 5 years. As a minimum, a certain amount, you get 7. I've seen recently 18.5 years, and calculations based up to retirement. The difficulty is that if you can reach an agreement with HMRC, obviously it's between you and them. It's not in the public domain. It's not a matter of record. It's just an agreement between you and your creditor. Now, the reality is for some people, that is going to be unpalatable. And also, I think to some degree, arguably impossible. How you enter into a time to pay agreement for 15, 16, 17 years when you don't even know what the world's going to look like in 15, 16, 17 months, and you're a contractor on a 6-month contract earning probably 60, 65% of what you were earning 10 years ago. And in your probably moving in towards your 50s rather than your 30s and your 40s and so on and so forth, that there are so many elements that have to be taken into consideration, and they are all case by case. Now, taking that into account, I mean, something like an individual voluntary arrangement is something that is potentially viable, and we've done a number of those. The problems arise in the fact that HMRC typically will look to reject an individual voluntary arrangement where they're not being paid the substantial quantum or the whole of the counter avoidance tax liability. That's their stated position. But a lot of people do have a wide number of additional creditors. And that's also including the trusts. The trust loans themselves, it's actually a liability. It was written as a loan. And going back to the IHT argument, on the basis that it's being argued that it is a loan, then why should it not take part in the proceedings?
That's an interesting point. In fact, I hadn't quite made that connection myself. So that's an interesting thought that I'm going to keep in the background of my mind, I think. A question we've got from anonymous attendee that either you or Rehan could answer, perhaps, is HMRC ever, and to the others who asked questions, we've got a record of them. I'm keeping some for the end, the last few minutes. But from anonymous attendee, is HMRC ever likely to commit to stand back and allow the liquidator to take their misfeasance action before engaging the loan charge? Should they be doing that?
Well, the thing is that they're separate paths. The loan charge came in the loan charge was brought in through legislation. It's not about HMRC levying it. It's about the fact that the individual has to report that onto their tax returns. That then creates the charge. So, there are, I've got a number at the moment where, the HMRC, I've actually said to them that unless they do actually give me an assurance that I can actually go forward, then it seriously impacts on my ability to actually take those actions. The reason for that primarily being, if you would imagine that, let's say, for example, I'm taking action against director for misfeasance. I'm employing lawyers or whatever, and taking formal legal action against them. They then pay their loan charge. HMRC reduces the claim down to zero. My claim falls away, and I'm actually sitting there with adverse costs I could be personally liable for. It's not a pleasant thought.
From your point of view, I can see the problem there. I mean, is that something that's happened to with HMRC?
Well, HMRC are, generally speaking, they are supportive. I think that the problem at the moment, and this probably is going to resolve itself over time, is we are still very, very early days. Now, HMRC have moved to preferential status as a creditor. That's very, very early days. HMRC have suddenly got the loan charge, very early days. What we're seeing at the moment is a cycle beginning to form, and what you've got is a number of competing layers creating friction, and over the course of time they will get dealt with. There will become let's say, an accepted way of working together. Now the reality is, as per any creditor, and HMRC are not alone in this. There are a number of creditors, lenders, etc. out there. If a lender has a personal guarantee, the fact that you are a liquidator of the company and you're pursuing the directors for claims doesn't preclude them from actually pursuing the individual under their personal guarantee. That's been the case for decades and decades. If that individual then pays that liability in full, that creditor disappears off the map. So this is not a new problem, it's just a new problem to be addressed with HMRC. The one thing which I would say HMRC have been very positive about is actually making sure that you as a liquidator engage, that you actually do the investigations that you need to do, that you make conscious decisions about what is acting in the best interest of creditors. They expect a level of engagement, they expect a degree of transparency. And likewise, on the other side, they will share information with you as a liquidator. You have to remember with a lot of these schemes, most companies keep their records for 6 years. The vast majority of this paperwork is gone. You as a liquidator coming in and gathering the books and records, you have knowledge, maybe you can identify issues, you have access to the directors who obviously may have participated, but in some instances, the former directors. In a number of instances I've dealt with, the company has subsequently been sold. Effectively is sitting there dormant, but with a large liability in it. In some instances, companies have been dissolved, and they will be brought back and reconstituted potentially, with a view to a liquidator then reviewing the affairs. Now, the reality is you're not necessarily going to have, I'd say in a good number of cases, you don't necessarily have a beautiful set of shiny books and records that joins all the dots and tells you how this worked and who participated and what the values were.
No, indeed. As you talk about HMRC sharing information with you, does that go the other way around? Do you share information with HMRC?
We consult with them. Creditors are invited to bring any information to the attention of a liquidator that would assist with their investigations. HMRC will do that. That then helps our investigations. We don't necessarily hand stuff back to them. We will obviously have a duty to keep them informed. So it's not a matter of passing correspondence backwards and forwards. It's a matter of engaging with them positively for us to achieve our duties.
Thank you very much. I don't know about you guys, but I think we could probably move on to questions that we have now. Again, from anonymous attendee, although I'm guessing from different anonymous attendee, what is the position with the tax liability if the company, in the company, if the loan is repaid rather than the loan charge being paid? Perhaps that's a question for Thomas to deal with. We still have you. There we go.
Yeah, sorry. Yeah, so first of all, it depends on when the loan was repaid. If it was prior to the 5th of April 2019, it may, if it was repaid in full and in cash, it may remove any liability from the loan charge as such. If it was repaid after the 5th of April 2019, it won't do anything to affect the loan charge. However, there are a few more issues in relation to this. I know yourself, Alex, you've had a client recently that you've assisted with this, and so you almost need to follow through what's actually going on. And effectively, money is leaving a company, which is generally an employer, and you need to understand how the money is leaving the company and going to a third party. Now, generally under the Ranger's principle, if earnings are leaving an employer and going repaying a debt on behalf of an employee, that will then give rise to a tax liability in the way that depending on how the money has left the company. There are also issues as well in relation to money going into a trust, potentially giving rise then to another Part 7A charge, which I know, again, you've had a client this has happened to that seemed to rush through certain actions to try and repay the loans quickly without thinking about the consequences, and has duly repaid the loans, and then the money came back out again and was almost, well, is effectively going to have to pay tax twice on that because an additional charge has now arisen. I don't know whether you have anything further to add in that regard.
Sorry, I was going to say, in terms of the company itself, more often than not, the biggest issue is the money's been extracted from the company, been paid to a, let's say, a trust. That trust is then obviously given a loan to the individual. The individual repays the loan back to the trust, but there is no mechanism by which the trust can repay that money to the company, because it was a one-way door in the first place. It was never designed to actually be a, and therefore what actually happens is that the original payment going from the company to the trust attracts tax. The fact that you've repaid your loan back into the trust does not negate that. So the tax liability still sits in the company.
Yes, that's a good point. In fact, repaying the loan gets rid of the loan charge, but that doesn't mean that the original payment, which may itself have triggered the disguised remuneration rules, still sits there.
Yes.
It's in few cases, I suppose, where the loan charge is triggered when the original payment wouldn't be.
And one of the interesting bits, which probably isn't going to be a helpful thing to say, but of course the other thing is if you then extract the money back out of the trust to actually pay it to the company directly as a personal settlement, the extraction from the trust will attract tax.
Indeed, it could. And quite a specific question, this one. Again, this perhaps goes to Thomas. What if someone has been, and I should say this is also from an anonymous attendee, what if someone has been settling with the help of a solicitor, and HMRC set out a final settlement letter to be signed, and that's sent back by recorded delivery with a query regarding the figures, but HMRC don't reply to that until after the 30th of September, send out another letter stating you missed the deadline to settle and must now pay the loan charge. I think we've seen this, haven't we, Thomas?
Yes, absolutely. This is something we've seen quite a lot of. So the difficulty that a lot of people found themselves in was that they'd been corresponding with HMRC for 12, 18, 24 months. And within probably the last month before the deadline, HMRC was desperately trying to get the settlement letters out to allow people to settle. Fundamentally, the deadline was the 30th of September 2020, and that was always the deadline. There was no, I suppose, legal basis for the settlement deadline as such, other than the fact that in the alternative, you must have reported the loan charge on your tax return and obviously paid the corresponding tax. Now, there have been a number of circumstances that we have seen in particular where there have either been extenuating circumstances on behalf of the individual for reasons that they couldn't respond on time, or where HMRC has potentially been at fault in terms of delay that they have caused. I've personally had a client that has been granted an extension to the settlement deadline on the basis that HMRC effectively failed to issue correspondence quickly enough. One of them was given correspondence 2 days before the deadline and expected to sign it. Where there were questions in relation to the actual figures themselves, and so the process for dealing with that is usually through the complaints process, and you are usually dealt with by an independent officer. They are generally quite reasonable, and what it's worth doing is setting out why you think effectively there are either extenuating circumstances or that HMRC has contributed to the fault. There would absolutely be an argument there if the figures had been presented to HMRC well in advance of the deadline. HMRC then has either made an error or they responded very close to the deadline, which then made it almost impossible to rectify this, because you're almost left in a situation where you either accept an erroneous settlement or you just don't settle. And it's these sorts of points that should be emphasised with HMRC, and hopefully then an independent officer or through the complaints team would then be able to give rise to an extension on that basis.
And have you had any success with that?
Yes, absolutely. I actually had a phone call last evening from a HMRC officer who had granted an extension on the basis that the correspondence that I received from HMRC in, I think it was in August time, didn't actually specify the internal deadlines that they were setting. So I know people will have probably seen that, and had actually issued the paperwork very late on. I think, again, it was probably a few days before the 30th of September, and therefore they've now agreed to a settlement extension into January, which is great news for the taxpayer, because he was very worried about having to report this on his tax return.
Well, that is a common theme. I think the feelings of individuals facing this, well, it's deeply distressing. It truly is. Now, here's an interesting question for anonymous attendee. I'm unclear whether the automatic incurrence of the loan charge on the individual after September 2020 ? In turn has the automatic effect of transferring the tax liability from the company to the individual, or does that transfer of liability, i.e. the company's liability, is in effect extinguished, only occur when the individual settles the loan charge? Well, I think there might be two parts to that. The first is the tax liability to the company, and the second may be the any other claimant the insolvency practitioners may have. As to the first, I think it's worth remembering that the loan charge treats the loan that's outstanding as income that has been deemed to have been received. Now, that could give rise to a liability to the company under the PAYE scheme. It could give rise to a liability to the individual, and that depends on the usual interplay between those regulations and factors such as where the company is, whether it's UK resident, and so on will apply there. So a bit of a fudge of an answer, maybe. It depends type answer. I don't know if Thomas would expand on that, and whether Brian has got anything to add about the company's liability to the insolvency practitioners.
Yeah, well, the company's liability is different.
Yeah,
so different basis of calculation, although effectively, yeah, there are elements within it. So the argument would simply be, if you paid the loan charge, it's money that's been paid to HMRC. That would then potentially reduce HMRC's claim in the liquidation on a pound for pound basis. But that still doesn't actually address settlement. It's payment of a particular sum. Now, the reality is that the liability in most corporates is more than the loan charge. Yeah, usually quite substantially more. So all they would do is literally reduce it down. It doesn't therefore remove the claim. It doesn't mean the claim is extinguished. Hence, going back to the rationale of a tripartite agreement, whereby there is and unfortunately the loan charge doesn't apply in this particular way. But if you think about it, if you pay the loan charge, there's still a liability left outstanding. It's then a matter of settling that residual liability.
Thank you. Now, this is an interesting question for me, particularly. Anonymous attendee, if one settles with HMRC and pays the right amount of tax and loan charge, can the umbrella companies or companies acting on their behalf ask for the loan back as if it was an actual loan? Do they have any chance of winning that, since it wasn't a loan in the first place, just a scam? I've been dealing with a substantial case where a third-party company had debt purchased, I suppose, like mortgage companies do. They buy and sell mortgage debts, which the subprime market lending scam made that famous. So a third-party company purchased these loans, ? Was it connected to the original scheme promoters? You might think that, I couldn't possibly comment. And that a lot of the individual contractors who are facing claims from that third-party company are resisting very strongly those claims for loan repayments, precisely on the basis that it wasn't an enforceable loan in the first place. Now, we haven't seen the resolution of that yet, I'm afraid. Lawyers have become involved, and we wait to see how that does resolve itself. But ultimately, from a company point of view, the company would, if it's disputed, would have to prove the debt in court. But I should imagine the dynamic is a little bit different if a liquidator is involved, because I would imagine you guys can't just be persuaded to go away easily.
Well, from our angle, it's an asset that needs to be recovered. So we would have to look at how we recover it. And I suppose if we recover it, But then I suppose from even pre or post liquidation, the loan, I mean, I've not seen the loan term. Someone mentioned this to me a couple of weeks ago as well. That's a third party's chasing us for it. But the loan agreement itself, does it have repayment terms, and is it repayable? That's, I suppose, the logical questions that you need to ask, even if it's in a liquidation or outside of liquidation. And that, I mean, I'm not a lawyer, but would that mean it's a repayable debt?
Well, I think.
Sorry.
I think one of the bits there would be most of the schemes, the actual loans that came from the trusts are repayable on demand. It's actually, typically in the documentation is repayable on demand. It's designed to be a loan in essence, because otherwise the scheme wouldn't work. So the documentation actually holds up as being a loan. However, the people who participated, they knew at the outset that it was expected that they would never have to repay this. And in some instances, there were, whether it be bonds or other things that were put in place so that over a period of time they would mature and the loan would be repaid. So that there is one trust which went into liquidation. There's a bond which was put in place which was supposed to mature over the course of 30 years. That would repay the loans. The loans are repayable on demand. The liquidator in the first instance did actually send letters out and say, you got a loan, this is the amount that's outstanding, please pay. Then there was let's say you had the competing piece of the liquidator actually pursuing individuals for a debt and HMRC pursuing them as well, obviously in relation to settlement and the disguised remuneration elements. And rationally and ultimately the two parties came together, and HMRC and the liquidators agreed that if you settle the tax liability in relation to this scheme, then neither party would take any action. So you ended up back at a tripartite position.
Have you had, Brian or Rehan?
Sorry, a lot of these tax schemes that a lot of these directors took place, they took them on the basis that they took professional advice from their accountant, their tax advisor, or whatever. And a lot of the frustration that when I speak to a lot of these directors, they're saying, well, we took professional advice and they said to me it's fine. Why am I expected to pay it back? Now, has anything come to light recently about the fact that they've taken reasonable advice from a professional and therefore it's not payable?
Well, HMRC's position on that generally is the fact that it's not independent advice. What happened in a lot of situations was, the advisor passed them to a promoter. The advice was given by a promoter. Many of them saw counsel's opinion or whatever. But the documentation that's been signed in most instances, you say you are fully aware of the risks. You know what you're doing. The buck stops with me. And as I say, in a number of instances, HMRC's argument is that you took the advice of the person who's actually selling you the car. They said buy the Mercedes, it's great. Buy the Saab or whatever it might be. Best thing you'll ever do. And it's not independent advice. And there's been a few things on that in respect of. I'm actually aware of one case where the directors have actually won. Well, actually, I say won. They reached a mediated settlement with a party who was advising them. But in the main, generally speaking, it's not something that's being accepted at this particular point, unless somebody did actually go and get third-party advice.
Wasn't there some recent case law that changed this, Thomas?
So in 2017, from a tax perspective, now I imagine that there is a diversification in the way that professional advice is considered in an insolvency perspective in comparison to a tax perspective. So there was a change in the law in 2017 in relation to the advice that somebody may rely on. So effectively, prior to that point, you could, or HMRC couldn't necessarily ignore advice that was given by a promoter where, for instance, they had professional standing in their own right, because the promoter rules are so broad. So there could be circumstances where a professional person, such as a solicitor, barrister, tax advisor, IFA could provide professional advice and also be a promoter at the same time. However, from 2017 onwards, you now have the concept of excluded advice, where you cannot seek to rely on that advice that has been provided by a promoter, whether or not they are a professional in their own right. And therefore, where you then look at concepts such as carelessness and reasonable care, if you haven't then taken reasonable care, potentially you could then be careless in that circumstance.
I think we may have time for just one very quick question to wrap things up. This is a question from Claudio Bacchi, Dragoni Partners LLP. What is the window of planning opportunity or time frame left over in 2021 for employers or employees still undecided on their loan charge position? What do you think on that, Thomas?
So in terms of scope for planning, it's probably non-existent as such, because the loan charge, if it arose, would have arose as of the 5th of April 2019. In terms of steps for mitigation, it will probably be in the sense of, can we speak to HMRC and try and negotiate a settlement, a convenient settlement for all? And again, this might be where the insolvency guys come into it as well, to see where there might not be the money to repay all of the debt. Is can you come to some sort of negotiation in relation to saying, well, we're going to give you something, if not you're going to get nothing? Or again, in the alternative, could an IVA or something like that be considered? So HMRC does get something, but in relation to the actual tax liability itself, it's now crystallised, and there's nothing that can really be done. I've seen a few unfortunate people that have sought to repay their loans after the 5th of April 2019, and that didn't do anything to help the loan charge, and also gave them a few problems in terms of the money then that they want to take back out in the future.
Thank you, Thomas, and thank you all, and thank you everyone for attending. It says in my notes here that Alexander, to summarise what has been said, well, that is quite a challenge. I think we've covered an enormous spread of subjects. We've explored where we are at with the loan charge. There is perhaps some prospect of the loan charge being challenged in the High Court. Whether or not there's any likelihood of success in that, personally, I'm not terribly optimistic. I suspect that the direction of travel in the courts is perhaps against tax avoidance schemes of this nature, but we do wait and see. Open dialogue with HMRC perhaps is the other approach to be taken here. And really, I think what I'm gathering from Rehan and Brian as well is that really chimes also with dealings with insolvency as well. I don't know if that is a good summary of what they've said. That's all the time we've got for you today, I'm afraid. So thank you to all of you for joining us. I hope you found this webinar useful and interesting. I hope. I certainly have. I've picked up a few bits on the way, which is fantastic. Our contact details are up on the screen, so please do get in touch if you want to follow up anything with us individually. I'm certainly open to an email or a telephone call. I'm pretty sure the other guys will be. I will now wish everyone a very good Christmas, and please do stay safe.